Mr. Johnson,
Get out of here.
let me ask you a question, Mr. Johnson. Where did you get mail in 2015?
Sir, really, I don't get any mail.
All right, counsel, go ahead and put your appearance on the record for Westminster.
Good afternoon, Your Honor. Stuart Collis, P49530, on behalf of the plaintiff.
And Mr. Johnson, your name.
Aaron Johnson.
Thank you. And I think we've got two things up today. Mr. Johnson's filed some objections to garnishments, and he's filed a motion to set aside a default judgment, correct?
That is an
That's
accurate
cool.
statement, Your Honor.
All right, so let's talk about the motion to set aside the default judgment. What was the default for, Mr. Collis? Was that a fail to answer, fail to appear? What was the reason for the default?
Over 10 years ago, it was a failure to appear. There was alternate service in this matter. It was achieved in October of 2015, with proofs of services apparently filed in November and December of 2015. And looking at the documents, it looks like, let me see here, going back, into 2015, that the envelope for certified mail was returned unclaimed, and the first class mail, of course, went there, and there's tacking done as well. Judgment was entered on excuse me, I'm getting over a cold, Your Honor.
That's all right.
Judgment was entered on 1/25 of 16. The clerks mailed it out on 2/2 of 16. No response was filed. We filed garnishments in March of 16, tried a creditor's exam in 2019, which wasn't served, tried a different garnishment in 2020. And then when we filed this motion to renew, this is the first time we heard from Mr. Johnson.
Okay. All right, Mr. Johnson, you have filed with your motion to set aside two attachments. One is a good cause statement and the other is a meritorious defense statement, attachments 1 and 2. Is there anything you want to add to those written arguments?
Yes. Well, actually, I have an understanding that a lot of things were supposed to have been falsified as far as in my documentation, and that was very much inaccurate.
Okay, what was very much inaccurate?
Far as he claims that I was I'm sorry, I'm a little tired. I've been up for quite a while. That my document was falsified. I have records, books,
Okay,
stating that this.
okay, hold on. Mr. Collis claimed something was falsified?
Yes, he said that the paperwork that I sent when he sent the motion, that a lot of my paperwork was falsified. I have documentation, sir. I have to keep.
Mr. Johnson, I don't know what you're listening to because I didn't hear him talk about anything that was falsified. I heard him give me a rundown on the history of this case. So let's get back to my question. My question is, you've submitted some written documentation. Do you have anything to add? Let's do them one at a time. Your good cause statement. Do you have anything to add to that statement as to the reason why you failed to answer the lawsuit?
Yes, sir. I was. What's going on here?
Too many people talking. Try it again.
Okay. Yes, I'm an over the road truck driver. So
I see that in your document. Is there anything you want to add that's not in the document?
I pretty much stayed in Illinois for almost 6 years, sir.
Okay.
So I didn't know what was going on around this time. A lot of my information comes by digitally. It comes by email or etc. So whatever documentation was actually sent, I probably have not got it.
Okay.
And transition of my family, as far as moving from home to home, has been a situation. I have also there's no. I'm sorry, I'm sleepy. I'm trying to get all this stuff together. There's no way I can get any of the other addresses, as far as in whatever has been mailed. I can't get any of the other addresses that we had, like as far as in with the PO box and etc. So this thing is switching over to everybody else here.
Your Honor, what's interesting to me is that the address on Mr. Johnson's pleadings is the exact same address we had 10 plus years ago, and he was served at on Bay Hill in Romulus. So I have a difficult time believing that he didn't receive anything.
On the you talking about on the 15th, sir? Or the 2015? Because actually, you have to understand. Yes, the house was being built at that time. So yes, she was the house was getting built at that time. There was 3 addresses. She was transitioning from Winningham to Romulus.
Okay. Let me ask you a question, Mr. Johnson. Where did you get mail in 2015?
Sir, really, I don't get any mail. Everything was supposed to be going from transferring from
let me ask it another way.
PO box.
What was the official address that the U.S. Postal Office had for you?
I have no idea. They don't keep those records after a while.
Okay. At some point, did the U.S. Post Office deliver mail to you at that Bay Hill address?
Sir, I don't know because most of the time I wasn't here.
Okay. All right. So let's talk about your meritorious defense. You filed an attachment on that. Is there anything you want to add to that written statement about your defense to the underlying claim?
I'm sorry, I couldn't understand you, sir.
You filed an attachment number 2 titled Meritorious Defense. Is there anything you'd like to add to that written statement regarding your defense to the underlying claim?
Yes. I got this information from the ROA, which is that's a public record. And I have documentation here that's stating that it's $3,954 is what it was supposed to be potentially owed.
Okay, that's in your written statement.
Yes,
right.
That's pretty much about it on that one, sir.
Okay. Anything else?
No.
All right, Mr. Collins, anything by way of response to either argument of defense or good cause?
Your Honor, I think that we pointed out most of the flaws in our brief, and I would just rely on that.
All right, thank you. So, Mr. Johnson, I apologize because I usually start these types of motions with this little lecture, but so I'm going to give it to you now. When there's a motion to set aside a default judgment, there are 2 questions that the court looks at. Both questions have to be answered in the affirmative for me to set aside a default judgment. The first question is, was there a good reason why you missed whatever you missed? In this case, you didn't file an answer, and that's why the default was entered. So the first question is, did you have a good reason why you didn't file an answer? The second question, let me speak, sir.
I'm sorry.
The second question is, do you have a meritorious or do you have a good defense to the underlying claim from the plaintiff? I find the answer to both those questions is no. It's absolutely inconceivable to me that you don't know where you got mail at any point in your life. Obviously, that address was tied to your name at some point in 2015. I'm going to suggest probably onto the underlying account that gave rise to this lawsuit. And if you don't do a formal change of address with the post office, as far as anybody knows, that's your address. Now, on top of that, there was a court order authorizing plaintiff to serve you by doing 3 things: sending first-class mail to that address, sending certified mail to that address, and posting an actual written document on that address. If whoever was living in that home didn't share that with you, that is on Mr. Johnson. That is not on Westminster. For all those reasons, the judgment will stand, and the garnishment is the next discussion.
Your Honor, with regard to the garnishment,
why do you think the garnishment is invalid, sir?
Get out of here. Get out of here.
I'm in court. Get out of here.
Mr. Johnson?
Get out of here.
Your Honor, the non-periodic
Jesus
garnishment,
Christ.
quite frankly, even though I think that the objection should be deemed invalid, it's moot. There were no funds that were withheld.
All right, is that true, Mr. Johnson, that the garnishment did not bear fruit for the plaintiff?
No.
No, it's not true, or no, it did not bear fruit?
I'm sorry. Could you? Nothing came out of. I didn't bear fruit or anything. No.
So would you agree with counsel that your motion on that garnishment is kind of a moot issue because it didn't cost you any money?
I'm just gonna break it down like this. I'm not financially stable. I'm going to need a payment plan in order to do anything.
Okay, but that doesn't answer my question. Are you agreeing with the attorney?
You have to get out of here. Excuse me, sir. You have to get out of here.
All right. And I find the objections invalid. Goodbye, Mr. Johnson.
God damn it. Excuse me. All right, goodbye.
Thank you, Your Honor.
Counsel, you can submit an order on that if you'd like.
I will do so. Thank you.
In the end, the court refused to reopen the case. The judge ruled that Aaron Johnson failed to meet the legal standard required to set aside a default judgment. He did not show a credible reason for missing the lawsuit in the first place, and he also failed to present a strong, specific defense to the underlying debt. Because both of those elements are required under Michigan civil procedure, the 2016 judgment remains in force. The court also rejected Johnson's objections to the garnishment. Since no money was actually taken, the issue was legally moot, and there was no basis for the court to grant any relief on that point. The practical result is that Westminster keeps its judgment and remains free to continue collection efforts using lawful tools like garnishment. This hearing underscores a basic reality of civil court. Ignoring a lawsuit can lock in consequences for years, and once a default judgment is entered, undoing it requires clear proof, not just explanations.